This is the Owen J. Roberts Lecture in Constitutional Law, which for the first time this year is joined with appreciation by our colleagues in the Provost's office. So this is also the university's Provost Lecture on Diversity. We're so happy to have one of the country's most distinguished jurists, former law professor, Justice Goodwin Liu of the Supreme Court of California. Thank you, Justice Liu, for being with us, and thank you, because I know it was arduous traveling here and delayed a bit, your presence here in person, as well as your words of wisdom, which could have been delivered virtually, but it's more meaningful and wonderful to see you here. And for those just tuning in for the lecture, Justice Liu has been meeting with our students and faculty colleagues in the hours preceding this, so very generous and appreciated that you're here. My colleague, the Penn's Interim Provost, Beth Winkelstein, will more properly introduce Justice Liu in a few moments. Let me briefly do a couple of housekeeping things and then say a little more about the lecture, the history of this lecture. Justice Liu will take some questions at the end of the talk. To submit a question virtually, if you're listening remotely, use the Q&A feature found on the bottom of your window. In-person attendees, please use index cards, which my colleagues will provide you, and we'll collect those before the Q&A period. If you are taking CLE credit, you've got to write down a couple passcodes, and the first one, apropos of the Justice's lecture, is bias. Just the word bias is the first code. Let me give you a brief history of this Roberts Lecture. It's named for former Supreme Court Justice who did the unthinkable. He resigned from the Supreme Court to become dean of this law school, Owen J. Roberts. It was established in 1956 by the law school and was sponsored and continues to be supported by Justice Roberts' former law firm, Montgomery, McCracken, Walker, and Rhodes. The lecture is delivered by a prominent person in the fields of constitutional law and public policy. Prior speakers include Supreme Court justices like Felix Frankfurter. Just a few years ago, Supreme Court Justice Ruth Bader Ginsburg, for whom Justice Liu was a law clerk. Our own Dorothy Roberts gave the Roberts Lecture in a nice consanguinity there. John Rawls, Amartya Sen. So this is the kind of intellectual tradition that our current speaker follows in. Justice Roberts, Dean Roberts, was a graduate of this law school in 1898, served on the faculty, served on the Supreme Court from 1930 to 1945 before coming back to be dean. I would note, very apropos of today's lecture, of today's discourse around race and belonging in this country, Justice Roberts was one of 3 dissenting votes in the Korematsu case when he was on the court. He saw then, along with Justices Jackson and Murphy, that group-based stereotypes and ascriptions based on national identity were fundamentally un-American, inappropriate then, inappropriate now, and I as dean and we, acknowledge the fundamental wrongness of the Korematsu majority and the group-based stereotypes on which it was based. And I'm pleased that Justice Dean Roberts saw that half a century ago, and we still recognize how fundamentally anathema such stereotyping is to our enterprise and to our national and global values. And we'll hear more about that from our distinguished speaker. I'm now pleased to better introduce Justice Goodwin Liu. I will introduce colleague and friend, Interim Provost Beth Winkelstein, who's the Eduardo Glant Professor of Bioengineering and Neurosurgery. Sort of puts our law stuff to shame there, but before her tenure as Interim Provost, Beth served as both Deputy Provost and Vice Provost for Education and was a Penn undergraduate and a longtime faculty member here. So thank you for your partnership as well. Thank you, Laura Perna, the Vice Provost for Faculty, for partnering, and I'll turn it over to you and then to Justice Liu. Thank you.
Thanks, everybody, and thanks, Ted, and a special thank you to the entire law school for hosting us. Good afternoon, everybody. I'm going to build off Ted's comments and acknowledge that it's a great pleasure to welcome you to the 2022 Provost Lecture on Diversity, partnered with the distinguished Owen J. Roberts Lecture in Constitutional Law. So before I introduce our speaker, I want to provide you a few words about the history of the Diversity Lecture here at Penn and its importance to us as a campus and our shared civic life. The Provost Diversity Lecture was created as part of Penn's 2011 Action Plan for Faculty Diversity and Excellence, which we continue to build on. It's an opportunity to hear from both Penn faculty and experts beyond Penn on the essential role of diversity, inclusion, and equity in our scholarship, teaching, and professional practices, in our shared community, and in the wider world. Recent past topics have included the 2020 racial equity protests, gender equality and women's rights, and the many facets of identity and covering. Diversity, equity, and inclusion further Penn's institutional and societal responsibilities, among them achieving superior educational outcomes, promoting innovative scholarship, advancing equal opportunity employment opportunities, and strengthening democratic institutions. Few people are better versed in the ways inequity plays out within these institutions, and in particular the law, than our guest and speaker today, the Honorable Justice Goodwin Liu. Last year, after an unprecedented number of attacks on Asians and Asian Americans, Justice Liu noted in the Los Angeles Times the striking lack of diversity in the top ranks of the legal profession. Nowhere is this more true among the chief law enforcement officers of our cities, counties, and states, he wrote. He continued, in a 2017 research study that several colleagues and I conducted, we found only 4, not 4%, 4 Asian American elected prosecutors in all of America. California, where 6 million people identify as Asian American, has 1. What accounts for such outcomes? Increasingly, it appears that implicit bias plays a large role, and there's new scientific evidence to support this contention. Implicit bias is the topic of today's discussion. Goodwin Liu is an Associate Justice of the California Supreme Court appointed by Governor Jerry Brown in 2011. Before joining the court, he served as Associate Dean and Professor of Law at the UC Berkeley School of Law and received Berkeley's highest award for teaching. The son of Taiwanese immigrants, Justice Liu attended Stanford and then Oxford. From 1993 to 1995, he served as Senior Program Officer at the Corporation for National Service in Washington, D.C., where he helped launch the AmeriCorps National Service Program. He has written widely on education policy, constitutional law, and the Supreme Court, occasionally with very strong opinion. We'd expect nothing less. Please join me in welcoming the Honorable Justice Goodwin Liu.
Thank you so much. It's wonderful to be here at the University of Pennsylvania and wonderful to be in person. And for those of you who are on Zoom, I'm glad that Zoom has broadened our horizons in terms of access to programming, so we're having the best of both worlds here today. I'm very honored to be giving the Owen J. Roberts Lecture in Constitutional Law, and then doubly honored to also have this be the Provost Lecture on Diversity at a time when we're having a lot of debate and discussion in this country about whether we even should be talking about these things. I think it's notable that this university has committed a lecture to this important topic. This has been a topic of very long personal and professional interest to me. Like many people who grew up in an immigrant family, I have had my own share of experiences navigating cultural and racial ethnic differences. As a judge, I've seen these issues in my daily life. Implicit bias, structural bias play out in areas like jury selection, search and seizure, the criminal justice system writ large. A couple years ago, I was asked to co-chair a National Academy of Sciences workshop on implicit bias, the science of it, which brought together many of the top psychologists, neuroscientists, economists, and legal experts in this area. And a lot of what I'll show you today draws on this work. The planning for that workshop occurred right at the beginning of the pandemic, started then, and we could not have foreseen how the world literally would change before our eyes. The murder of George Floyd in May of 2020 galvanized a worldwide movement for racial justice. We also saw a disturbing rise in anti-Asian incidents, punctuated by the Atlanta spa shootings last March. And so all of this was a matter of both lived experience and dispassionate science coming together to really underscore the urgency of discussion of these topics, and it's in that context that I offer these remarks today. So I want to talk about two ideas, implicit bias and structural bias, and these terms are often used without clear definitions, which can make the concepts imprecise, overbroad, and vulnerable to caricature. So my aim today is to strive for some more precision and nuance on these issues. And the good news, I think, is that we've never been in a better position to do just that in light of the evidence and the science that we have behind these topics. So let me begin with implicit bias. Let's see, here we go. Okay. So here's an example. Some years ago, I was on a flight, ironically, to give a talk about implicit bias. And I saw this icon in the airplane lavatory, and I thought, oh, wow, perfect example of implicit bias, right? Look at this icon for a little while, okay? And so I included this example in my slides that day. And then when I got home from that trip, I showed this icon to my then 9-year-old daughter. And I asked her, what's wrong with this picture? She looked at it for a little while and said nothing. And so I said, well, don't you see? Why do we assume that the mommy is the one changing the baby? What about the dad? Isn't that unfair? And I swear to you, without missing a beat, she replied, not if the baby has two mommies. So, my attempt to illustrate implicit bias just revealed my own implicit bias, right? So here's a working definition. Implicit bias is a preference for, aversion to, attitude toward, or stereotype about a group or a person based on group membership that is outside the realm of consciousness and not subject to our direct introspection, okay? So these attitudes or stereotypes arise from the ordinary cognitive processes that our brains use to interpret and categorize the multitude of sensory inputs we encounter every day. These processes occur automatically and uncontrollably outside of our awareness, and they are often helpful, actually, in navigating the world around us. We can't individuate every single observation we make every day, so we generalize, and it helps us. But when our minds apply these shortcuts to how we treat or judge other people, that can be problematic. The baby changing icon may convey an implicit bias regarding gender roles, even as that reading of the icon suggested another bias that I was not aware of. So as that example illustrates, our implicit biases are often at odds with our conscious beliefs or intentions. Now, implicit bias is not the same thing as hidden bias. There are situations where an employer, for example, refuses to hire a candidate ostensibly because of her qualifications, but in actuality because the employer anticipates she will get pregnant or spend too much time on childcare or take leave or whatnot. This is conscious bias cloaked by pretext, and there are legal standards designed to smoke out bias of this kind, but that is not implicit bias. Perhaps the most well-known metric of implicit bias is the implicit association test. This is a test that asks people on their phones or their laptops to sort two social categories, for example, black faces and white faces, with two sets of words, those with good connotations and those with bad connotations. And then it measures the response times at the level of milliseconds in making stereotypical associations like white faces with good words versus non-stereotypical associations like black faces with good words. And there are multiple variations of this test along a variety of social dimensions you see there, and you can take it yourself at the website. I encourage you to do so. Over the past couple decades, millions of people have taken this test, and 3 findings are noteworthy. First, unsurprisingly, implicit biases favoring culturally dominant or socially valued groups are strong and pervasive. Second, in-group biases are clear and robust. For example, white women favor white women, although the extent of favoritism varies across marginalized groups. So for example, black people, and in particular black men, show the least in-group favoritism. Third, apart from in-group bias, implicit bias is not significantly different by race, gender, level of education, or political ideology. The point being, no one is immune. Not me, not you, not any of us. So some people then ask, okay, well, does that mean we're all racist? Does that mean we're all sexist? Well, my answer to these questions is no. I think those labels suggest a mindset of malevolence or antagonism, and overextending these labels is unhelpful. Not only does it obscure understanding of implicit bias, but it also turns such bias into an accusation. We should not conflate implicit bias with conscious bigotry. At the same time, we should be mindful that it's easy to call out conscious bigotry, but much harder to address implicit bias, which is pervasive and entrenched. We know so much about implicit bias today thanks to 20 years of science, and this research is both important and just plain fascinating in its own right, so I'm going to spend a little time on it. Here is a field study many of you probably have heard of. These researchers sent 5,000 resumes in response to over 1,300 want ads, real ones, for sales, clerical, admin support jobs in Chicago and Boston newspapers. Half the resumes were randomly assigned stereotypically black-sounding names like Lakeisha Washington or Jamal Jones, and half were assigned stereotypically white-sounding names like Emily Baker or Emily Walsh or Greg Baker. The researchers also crafted 2 resumes, one higher quality and one lower quality. And in response to each ad, they sent 2 higher quality resumes, one black, one white, and 2 lower quality resumes, one black, one white. Okay? Here are the results. Resumes with white-sounding names produced a 50% greater callback rate than resumes with black-sounding names. Those are the middle 2 bars. Moreover, the difference in callback rate for high versus low quality resumes was much smaller for black names than for white names. So the premium to having a better quality resume was so much less for black-sounding names than for white-sounding names. In fact, if you look carefully at the top and the bottom bars, low-quality resumes with white names got more callbacks than higher-quality resumes with black names. Here's a similar audit study on university professors, just to bring it right home here. These researchers sent an email to more than 6,500 randomly selected professors from 259 American universities. Each email was from a fictional out-of-town student expressing interest in the professor's PhD program and seeking guidance. The emails were identical, except for the name. They used names like Meredith Roberts, Lamar Washington, Juanita Martinez, Raj Singh, and Chang Huang, which were consistently perceived as white, black, Hispanic, Indian, and Chinese, respectively. They used 20 different names in 10 race gender categories, for example, white males, Hispanic females, etc., and each professor was sent 1 email. The results? Well, Overall, 67% of the faculty members responded. That's good. Professors, you all read your emails, that's good. And 59% agreed to meet with the student. But professors were more responsive to white male students than to female, Black, Hispanic, Indian, or Chinese students in almost every discipline and across all types of universities. The most severe bias was observed in disciplines paying higher faculty salaries and at private universities. Business professors showed the most bias, with 87% of white males receiving a response compared to 62% of women and minorities combined. Interestingly, Chinese students were the most discriminated against group, suggesting no benefit from the model minority stereotype. And also interestingly, no in-group favoritism was observed except when Chinese students emailed Chinese professors. A Black student emailing a Black professor produced the same level of bias. Finally, the results were no better in disciplines with more women and minorities. Faculty in more diverse disciplines like criminal justice were no less likely to discriminate than faculty in less diverse disciplines like statistics. Here's a study. This is the fair treatment of the Owen Roberts Lecture and the Provost Lecture on Diversity. Here's a study that hits close to home for law. The researchers in this study drafted a legal memo about a made-up problem involving trade secrets in internet startups. This memo had 22 intentional errors in it. 7 of them were spelling or grammar errors, 6 were technical writing errors, 5 were errors about the facts that were given in the sample problem, and 4 were errors in analysis. And the memo was said to have been written by Thomas Meyer, a third-year associate with a degree from NYU Law School. Okay? 60 law firm partners were asked to rate the memo on a 5-point scale, 5 being the best, and to offer feedback to Mr. Meyer. Thomas Meyer was identified as white to half the partners and as Black to the other half. Results. The same memo got an average rating of 4.1 when written by white Thomas Meyer, 3.2 when written by Black Thomas Meyer. The comments. White Thomas Meyer was said to be a generally good writer, but needs to work on, X, Y, and Z. He has good potential, good analytical skills. Black Thomas Meyer was said to be average at best, needing lots of work. One partner said, "Can't believe he went to NYU." Most interesting to me about this study were the differing rates of objective error spotting. A misspelled word is a misspelled word. Out of 7 spelling or grammar errors, an average of 2.9 were found in white Thomas Meyer's memo, 5.8 in Black Thomas Meyer's memo. Out of the 6 technical writing errors, 4.1 in white Thomas Meyer's memo, 4.9 in Black Thomas Meyer's memo. Out of the 5 errors of fact, 3.2 in white Thomas Meyer's memo, 3.9 in Black Thomas Meyer's memo. And there was no significant correlation between the race or gender of the partner evaluating the memo and this pattern of error spotting. Well, if we're going to talk about lawyers, we have to talk about doctors too. There are many studies on implicit bias in medicine. Here's one where 720 primary care physicians were shown a recorded interview and other data about hypothetical patients with chest pain. 8 actors, reflecting different combinations of race, gender, and age, recorded the interviews based on established scripts. And the physicians were asked whether they wished to refer this patient for cardiac catheterization. The study found that the race and sex of the patient affected these referral decisions, even when controlling for the physician's estimates of the probability of coronary disease and other factors. Women were referred less often than men, Blacks less often than whites, and Black women significantly less often than white men. Many people have been concerned about implicit bias in law enforcement and the criminal justice system, including police shootings of unarmed Black men. So researchers have developed an experimental task called Shoot, Don't Shoot to examine what's called shooter bias. In a typical task, participants see on their screens a Black or white person, usually a male, holding either a weapon, like a gun, or a neutral object like a cell phone, a soda can, or some sort of tool, right? They are then given less than 1 second to decide whether to shoot or not shoot this person. So among participants from the general public, like college students, there are consistent findings of shooter bias. In other words, shooting unarmed blacks more often or more quickly than shooting unarmed whites, or not shooting armed whites more often than not shooting armed blacks, or being slower to decide not to shoot an unarmed black man than unarmed whites. Okay? These are all forms of shooter bias. Among police officers, however, the findings are mixed. One study found that police officers had reaction time biases, meaning they were faster at shooting armed blacks and they were also faster at non-shooting unarmed whites. But they did not err by shooting unarmed targets. There's evidence that giving officers more time to evaluate the task can neutralize shooter bias, and that training can equip officers with cognitive control to counteract these biases. But all of these studies are very careful to note that shooter task measures are not necessarily predictors of real-world decision-making. And research is only beginning to evaluate the efficacy of implicit bias training for officers. So, for example, a recent study of 15,000 officers of the NYPD found that an 8-hour implicit bias training resulted in no changes in racial disparities, in arrests, stops, frisks, searches, uses of force, and the like. Here are a pair of studies by Stanford social psychology professor Jennifer Eberhardt, who won a MacArthur Award for her work on implicit bias. In the first study, 62 white voters at the Caltrain station in Palo Alto were asked whether they would sign a petition to support a 2012 ballot measure to make California's three-strike sentencing law less punitive. Okay? The voters were primed with a rapid series of male inmate photos on an iPad, 80 photos in 40 seconds, so they're just going really quickly on a screen. And these photos were either 25% black, or, which is the percentage of blacks in California prisons, or 45% black, which is the percentage of three strikes inmates, okay? And then the voters were also asked to rate how punitive they thought the three strikes law was on a scale of 1 to 7, 1 being the least punitive. Well, the result was that over half of the voters primed with photos with fewer black inmates, the 25%, agreed to support the ballot measure, but only 27% of voters primed with photos with more black inmates would sign. And the racial composition of these images predicted these rates of petition signing even when you control for how punitive voters thought the law was. Right? And the second study is very similar. 164 white New York City residents were asked whether they would sign a petition to end the city's stop and frisk policy. Some of these voters were told that inmates are 40% black, which is the US prison population average, while others were told it was 60% black, which is this New York City figure. And you see the disparity. 12% who were told the more black condition said they would sign, compared to 33% who were told the less black condition. This research on implicit bias extends even to professional sports. These researchers assembled a database of almost 600,000 foul calls from 13 NBA seasons from 1991 to 2004. And they controlled for player styles, refereeing styles, and other variables, and found that white referees called fouls at a greater rate against black players than white players. And black referees, to a lesser degree, called fouls more often against white players than black players. This in-group bias, own race bias, in the data was large enough to affect the outcome of an appreciable number of games. Given the number of NBA games that are won by just 1 or 2 points, just one extra foul call can tip the balance. I would add there's a 2011 study of Major League Baseball with a data set of 2 million pitches. Similarly, finding that umpires, all else equal, call a pitch a strike about 1% more often if the umpire and the pitcher, are of the same race. That number is not big enough to tip many games, but it's still pretty interesting. It's possible that what these studies reveal is actually conscious, not unconscious bias, but I think that's unlikely for a number of reasons. The shooter and the referee studies involve the kind of high-pressure, split-second decision-making that allows our implicit biases to become evident. And for the other studies, if we could administer truth serum to lawyers, doctors, university professors, HR managers, or residents of New York City or Palo Alto, well, maybe some of them would confess to latent conscious biases, but I suspect most of them would insist that they are fair-minded people committed to diversity, equity, inclusion, just like all of you are. The point is that their observed biases are existing outside of their conscious awareness. Okay, let me turn now to structural bias, and I'll introduce this concept again with an example. So one of the most common issues that I encounter as a judge is racial discrimination in jury selection. In many states, litigants are given a certain number of opportunities called peremptory strikes to remove prospective jurors for any reason except discrimination on the basis of race or other protected characteristics. The Supreme Court has held that such discrimination is unconstitutional, but it is lawful to remove a juror for a race-neutral reason that is highly correlated with race. So you see very commonly prosecutors ask black jurors questions like whether they or their close friends or family have ever had a negative experience with law enforcement. That's like almost every black person in America, right? Okay, if a juror says yes, then a prosecutor can remove the juror on that basis. That's not considered racial discrimination. Well, it's not hard to see the problem here, right? As I wrote an opinion a couple years ago, the mistreatment of black Americans by law enforcement is itself a long-standing and serious problem. Current law then compounds and institutionalizes this problem by permitting the exclusion of black jurors based on the very mistreatment that they, their friends or family, or members of their community have experienced. And in turn, the conviction of black defendants by juries from which black jurors have been struck further reinforces perceptions of unfairness. This is structural bias. Here's a working definition. Structural bias is the perpetuation and often amplification of racial or other disparities across domains through facially neutral laws, policies, or practices that effectively, though unintentionally, function as racial criteria. Now, that's a mouthful, so I want to highlight three aspects of this definition. First, structural bias is a feature of laws, policies, and practices. It's a feature of institutional and organizational arrangements, not individual states of mind or cognitive processes. You know, the Jim Crow era taught us that discriminatory laws and processes can emanate from conscious prejudice. There's no doubt about that. But structural bias, as I'm defining it here, does not require a conscious mindset or any mindset at all. It is the compounding effect of a policy, not its cognitive origin, that is characteristic of structural bias. Second, structural bias perpetuates or amplifies disparities from one domain into others. In jury selection, the negative experiences that African Americans have with law enforcement are transmuted, right, into exclusion from jury service, which has then its own negative effects for black jurors and black defendants, which in turn reinforces perceptions of unfairness in the justice system. This mutual reinforcement of disparities across domains is another hallmark of structural bias. And third, although I said structural bias is not itself a cognitive process, laws and institutional structures can reinforce discriminatory beliefs and values. By entrenching disparities, structural bias can feed explicit and implicit bias. So, for example, as we saw in Jennifer Eberhardt's studies, over-incarceration of black men can feed perceptions of crime and resistance to policy reform. So research has provided very fascinating insight into structural bias as well. This is a study that compared county-level data on the percentage of the population enslaved in 1860 with present-day levels of implicit bias in those same counties. The 1860 map, based on the census then, was the one President Lincoln used to predict which states would be most committed to secession. The study found that white residents of counties more dependent on slave labor in 1860 display greater implicit bias measured up to 156 years later. That is a stunning finding. And it suggests the durability of institutional structures, right? There is no cognition that extends 150 years. The durability of institutional structures, from Jim Crow to, well, I should have started with the Black Codes, to Jim Crow, to residential segregation and beyond, that maintain social hierarchies over time. And so this study concludes that implicit bias may be better understood as a cognitive manifestation of historic and structural inequalities, and not solely as a feature of individual minds. The mechanisms of structural bias are perhaps most evident when it comes to residential segregation, which is both an outcome of race-based redlining, as well as a foundation for other policies that then limit education and employment opportunities, increase exposure to pollution, and restrict access to healthcare and nutrition. So this is an example. It's a study of 202 American cities, which shows that neighborhoods redlined by federal officials in the 1930s tend to have higher levels of air pollution 8 decades later. My own neighborhood of Oakland, Berkeley, which is up on the board there, is a prime example. Federal officials, this is the map furthest on my right, graded neighborhoods from A, the best, to D, the worst. And the other two panels show the concentration of air pollutants in this East Bay region. Red line neighborhoods toward the west, closer to the bay, sit on flat, low-lying land and have much higher air pollution today than the eastern hillsides where more privileged families live, including mine. One reason for this is the siting, S-I-T-I-N-G, siting of polluting industries and major highways in historically red-line areas. In this way, land use decisions have been, these are land use decisions that have transmuted, right, housing disparities into environmental and health disparities. In addition to conventional policymaking like land use decisions that compound racial disparities, there are more subtle mechanisms of structural bias in our digital age. This is a study that examines a single healthcare algorithm used to help identify patients for so-called high-risk care management programs. This is for people who have very complex health needs. It's a special program with more resources, right? This one algorithm informed important healthcare determinations for millions of patients by assigning each patient a risk score. So if you get like a risk score of 90 or above, you are referred automatically by the algorithm to the high care program, okay? But at any given risk score, the study found, Black patients were far less healthy than whites. So for example, just look vertically on the one to my right, the panel to my right. Take the 97th percentile of risk. At that level of risk, if you look vertically, Black patients had 26% more chronic illnesses than whites. Same risk score, but Blacks are sicker than whites. This means that Black patients were less likely than whites, if you look horizontally now, with the same level of chronic illness to be identified for enrollment. So the horizontal line shows same level of chronic conditions, but look at the risk ratings. A white patient with that level would have over 90 on the risk score, which might get them automatically into the program, whereas the Black patient is rated at about 80 or less, okay? This bias is so significant that without it, see, this is what I was illustrating, without it, the Black share of patients automatically identified for enrollment would have increased from about 18% here to 46.5%. The reason now, the researchers found, they dug even harder, what is the reason for this bias? Well, it is because the algorithm used healthcare costs as a proxy for healthcare needs. And the risk scores were based on predictions of future healthcare costs. Now, this is not unreasonable because costs and needs are correlated. But the difficulty is that it turns out for any given healthcare profile, Black patients generate lower costs than whites because they utilize healthcare less. They are less likely to receive treatment, whether because of lack of access, lack of trust in the healthcare system, or other factors. And so the algorithm would assign the same risk score to Black and white patients predicted to generate, say, $10,000 in healthcare costs, even though at that level, Black patients, because of lower utilization, are actually sicker on average than whites. So it's not hard to see, in light of this kind of thing, how algorithms in other areas, like loan qualification, tenant screening, or bail, might impound related biases based on credit scores, criminal history, or other racially disparate data. Okay, what does the law have to say about all of this? Well, the short answer is not very much. The basic framework of our anti-discrimination laws was crafted 2 generations ago when this problem was fresh in people's minds. For nearly 50 years, it has been settled that discriminatory intent is required to establish a violation of the Equal Protection Clause, and the Supreme Court has understood this to mean more than, I quote the court here, more than intent as volition or intent as awareness of consequences. It implies that the decision maker chose a particular course of action, at least in part because of, not merely in spite of, its adverse effects upon an identifiable group. Given this definition, unsurprisingly, courts have not treated implicit bias as a form of intentional discrimination. However, various courts and individual judges have recognized the existence and pervasiveness of implicit bias in the context of federal civil rights laws, like Title VII of the Civil Rights Act of 1964, which bans employment discrimination, or the Fair Housing Act of 1968. The Supreme Court has occasionally said that the disparate impact standard of liability under these statutes can be effective in combating subconscious stereotypes and prejudices. Under the disparate impact standard, an employment or housing practice that has a disparate impact on a cognizable group can be found discriminatory if the practice serves no legitimate neutral purpose or if the decision maker was not actually motivated by a neutral purpose. And at least one federal court of appeals, the First Circuit, has drawn extensively on implicit bias research to hold that unwitting or ingrained bias is within the ban on sex discrimination under Title VII. Also, in a number of recent moves, a number of state courts and legislatures have recognized implicit bias as a form of unlawful discrimination in the context of jury selection. When a lawyer is picking a jury, it's not hard to imagine the unconscious stereotypes that may be triggered by the fact that a juror of a particular race lives in a particular neighborhood, or works in a particular job, or dresses a certain way, or does not speak English as a first language, right? So the California legislature, mine, recently passed a statute barring the use of group stereotypes and discrimination, whether conscious or unconscious, in the exercise of peremptory challenges. The Washington State Supreme Court adopted similar reform, requiring claims of discrimination in jury selection to be evaluated from the perspective of, quote, an objective observer who is aware that implicit institutional and unconscious biases have resulted in unfair exclusion of potential jurors. In other words, the observer who has watched this presentation. The New Jersey Supreme Court has similarly held, under the state constitution, that implicit bias in jury selection is no less real and no less problematic than intentional bias. And last year, the Arizona Supreme Court eliminated peremptory strikes altogether from the jury selection process, in part because they are susceptible to implicit bias. Now, although these developments are only from a few jurisdictions, I believe there is a growing recognition, rooted in science and lived experience, that implicit bias is a serious issue and that the justice system is not immune. So, as the bench becomes more diverse, I think we will see more questions raised about the administration of justice. For example, whether jurors should be instructed about implicit bias before deliberating on a verdict, whether a juror's implicit biases can be surfaced through voir dire, and what steps judges should take to check our own implicit biases. Beyond issues like jury selection that concern the administration of justice itself, I think judicial recognition of implicit bias in case law has been infrequent and has not kept pace with science. When the concept's mentioned, it's often mentioned in dicta or in concurring or dissenting opinions of judges urging greater attention to the issue. And I think we're unlikely to see courts expand legal concepts of discrimination to embrace implicit bias for two reasons. The first is that litigation is an adversarial process for assigning culpability. And courts may be reluctant to assign culpability for biases that, by their very nature, arise from ordinary cognitive processes that evade our awareness. Courts may hesitate to transform what science characterizes as a normal feature of how our brain works into a liability. And second, the pervasiveness of implicit bias may, ironically, deter courts from rendering it actionable. Courts are generally careful to limit their role in our system of government. They may be willing to get their own house in order by addressing implicit bias in the justice system, but it's a tall order to address implicit bias in employment, housing, education, policing, all the areas where implicit bias can operate. Indeed, judicial restraint is why the Supreme Court declined to address structural bias under the Constitution. Disparate impact as a basis for equal protection liability, the court has said, quote, would be far-reaching and would raise serious questions about and perhaps invalidate a whole range of tax, welfare, public service, regulatory, licensing statutes, and that the court was not interested in doing. So if courts are not well positioned to address these issues, then it is up to policymakers, by which I mean not only legislators, but organizational leaders of all kinds. And as we've seen, implicit bias and structural bias are interrelated, so we need to address both, but how? Well, as for implicit bias, it seems to me there are two general approaches. One is to develop ways of ridding ourselves of such biases, and the other is to assume that we can't really rid ourselves of such biases, at least not easily, and instead work to prevent their operation or to mitigate their effects. As for the first strategy, the available evidence suggests that implicit biases can be lessened through various interventions, but the effect is very temporary. So in this study, the authors invited fellow scientists to craft 5-minute interventions designed to reduce implicit bias as measured by the black-white implicit association test. There were 18 interventions submitted, falling into 4 categories. One was exposure to counter stereotypes through stories or images. The second was intentionally controlling bias by silently saying to yourself, if I see a black face, I will think good, right? That's the exercise on the IAT. Third was priming people with egalitarian values, such as endorsing multiculturalism. And the fourth was perspective taking, which means asking people to put themselves in the other person's shoes, okay? And so the authors found that 9 of these interventions in 2 categories did work. They had an immediate effect of reducing implicit bias, but after 1 or 3 days, none of them worked. No lasting effect after at most 3 days, right? Now this is not surprising, perhaps, given that the interventions for this study were limited to 5 minutes. But other studies on implicit bias trainings, including the one I mentioned about the 8-hour training of NYPD officers, have similarly found only short-term or no effects. And so one concern for organizational leaders is that despite the ubiquity of implicit bias trainings, I'm sure you've done them, right? And the time and the resources spent on these things, we have not only very little evidence of the efficacy of these things, but very few careful efforts to evaluate them at all. Implicit bias training may help raise awareness, but it also has some risks. It could make people become more defensive, like, are you telling me I'm racist? Or it could make other people complacent or unaccountable, like, well, we all have it. There's nothing we can do about it, right? These are the real risks. So universities, corporations, governmental institutions can and should evaluate these trainings, at least to ensure they're doing no harm. That's real. And I would say that studies on sexual harassment training provide a very cautionary tale. According to my former UC Berkeley colleague, Lori Edelman, such trainings, in her words, do more to shield employers from liability than to protect employees from harassment. Right? I'm going to say, I confess I am skeptical that implicit bias training as we know it today can really do much to reduce our biases in any lasting way. Our implicit biases are an accumulation of a lifetime of exposures to media, books, conversations, imagery, advertising, movies, and more. The prospect of de-biasing ourselves by displacing dominant beliefs and stereotypes with a few hours of intervention just doesn't seem terribly realistic. As Professor Jerry Kang has written, our implicit biases are like old stains on a well-trodden carpet. Why should they magically disappear after a brief scrub? So if we can't debias ourselves very easily, then how can we prevent the operation of implicit biases or mitigate their effects? Well, there's evidence pointing to a few strategies. One is to slow down tasks and to increase time for deliberation. One study I mentioned earlier showed that shooter bias can be reduced in this way. Another strategy is blinding, right? This well-known study by Claudia Golden and Cecilia Rouse found that the advent of blind auditions, where the musician performs behind a screen, right, increased the number of women hired into symphony orchestras by 30% from the late 1950s to 1995. Justice Ginsburg loved this study. Many professors, of course, take the same approach to grading exams, right? And some judges take this approach to sentencing by insisting that a criminal defendant's photo not be prominently displayed on the cover of a pre-sentencing report. They don't want to know, right? It's also important in selection or evaluation processes to commit to the criteria beforehand and reduce ad hoc decision-making. Here's some evidence for that. So in this study, participants were asked to choose between Michael and Michelle for the job of police chief, okay? Some participants were told that Michael was streetwise and Michelle is formally educated, and they were asked, who would you pick? And so these participants favored Michael for the job. And why? Because they rated being streetwise as more important. Other participants were told that Michael is formally educated and Michelle is streetwise. Who did they pick? They picked Michael. Why? Because being formally educated is more important in a police chief's job, okay? Now, in the third iteration, participants were asked ahead of time, write out the values that are important for a police chief in advance. Sorry for the glitch there. Before they were told who the candidates were. And then, when they were asked, they picked the chief consistent with the value that they indicated. Okay? So, I give you these examples realizing that not every task can be slowed down, not every evaluation process should be blinded, and not every process can only rely on preset criteria. Some of them require some discretion on the back end. But hopefully these examples, right, can induce us to pause and consider our organizational processes more carefully. Let me conclude with one last study that suggests how implicit bias and structural bias are related. This study tracked two groups of female college students and measured their implicit stereotypes of men as leaders and women as supporters, okay? One group attended a women's college, the other attended a comparable co-ed college. The students' implicit beliefs about men and women in this regard were statistically equivalent when they started college, but then they diverged substantially after 1 year. As sophomores, the women's college students showed no implicit gender bias, whereas stereotypic beliefs increased among the co-ed students. Why? The key variable was the number of women faculty that the students encountered at both colleges, the more women faculty they encountered, the less they held implicit gender stereotypes. Okay? Now, these findings suggest that more sustained exposures to counter stereotypes in real-life contexts, in other words, lived experience, not compliance trainings, right, can have durable effects in reducing implicit bias. But the bigger question that this study raises is structural. How are we going to hire more women professors? How are we going to get more minority professors? How are we going to elevate members of disadvantaged groups and stop compounding the disparities they experience from one domain to another, right? Now, part of the answer may be to mitigate implicit bias, for example, in faculty hiring, right? But I believe this really misses the much larger arrow of causation that points in the other direction. Structural bias, the perpetuation and amplification of racial or other disparities across domains through laws, policies, and institutional arrangements, results in visible patterns and hierarchies that continually shape our beliefs about people and groups outside of our conscious awareness. Recall the stunning geographic relationship between slaveholding in 1860 and implicit bias today. I would submit, then, that the primary responses to structural bias must be structural, not cognitive in nature. These responses include laws and policies, to be sure, but they also include data collection to promote transparency and careful study of policies and their effects on marginalized groups. Implicit bias training could also be important, not necessarily because it's effective in debiasing us, but because it can promote such widespread awareness that policymakers must take such bias into account when crafting laws, allocating resources, and designing institutions. Okay, I'm just going to end where I began and say that there are efforts today to restrict or eliminate education about implicit bias, structural bias, and the like, and there's no doubt these topics can be uncomfortable and must be handled with care. But thanks to 2+ decades of research, we now know more than we ever have about the subtle yet consequential ways that bias operates in our society, and we have much more to learn about how to counteract such biases. It took me a long time to go through all of these studies, and I don't claim to be an expert. But as a judge, as a citizen, and perhaps most importantly, as a fellow human being, I value the fair treatment of other people, and I feel we all should be called to understand the full extent of the work that we have yet to do. Thank you very much for this honor. It's a pleasure to be with you.